Good evening. I'd like to welcome everybody to the May 11, 2016 meeting of the Ascension Parish Planning Commission. We'll call the meeting to order. All members are present except Mr. Foster and Mr. Christie. I think Mr. Foster is on his way. Would everybody please rise for the Pledge of Allegiance?
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, and can we get introduction of staff, please?
Stacy Webb, Secretary for Planning and Development.
Cody Morton, I'm the attorney for the Planning Commission.
Laverne Bourgeois, billing official.
All right, thank you. Next item on the agenda is the chairman's comments. Since I began my tenure as a commissioner on this body, we have been presented with and approved many new subdivisions and development. The decision and the process by which we approve these developments has been criticized by some who would wish that we as a body would utilize some type of boundless discretion to deny any and virtually every development that has come before us, even and especially those which have met all the legal requirements set forth by the Parish Council as promulgated in the Unified Land Development Code. Personally, I am uncomfortable with the thought that an appointed body, an unelected body, such as this commission, has or should exercise boundless or unfettered discretion. Such discretion plants the very seeds that bloom into at least the appearance of impropriety and at worst outright political corruption, where you see laws being protected and people being protected by laws, and then that same discretion used to deny people protection under the law. This has particular implications when the right to use property and property rights are intertwined with this notion of discretion. From the very founding of our country to modern times, one of the pillars of liberty has been the right to own property and the right to use that property in a manner that is consistent with the law. That's not to say that there can't be restrictions on property. There can be, as with any inherent fundamental right, such as those as life, liberty, and the pursuit of happiness. There must be some limitations placed on those by our government that inure to the benefit of an ordered society and to prevent chaos. However, when dealing with such freedoms, because they evolve naturally and because they evolve from our Creator, any such restriction must be narrowly drawn and serve only those goals, specifically protecting the health, safety, and welfare of the overall society. It was under this framework that a battle has ensued with this commission and been fought regarding the true authority that we have. Those who have argued for the use of our unfettered discretion to deny any development, especially those which have been formed under the laws, rely on a state statute 33, revised statute 33-101.1, which states that an act approving or disapproving a subdivision plat is declared a legislative function involving the use of legislative discretion by the Planning Commission. This body, both prior to the arrival of our new commissioners and even after, has been very reticent to interpret this statute as granting us unfettered discretion as we've been encouraged to use. Last year, I even made the comment that as long as any development met the established codes and the laws of our parish, we were bound to approve it, and any action approving or not approving an otherwise legal development would undergo strict scrutiny by the courts. In other words, any action that we took to deprive a landowner of his right to use his property in a manner consistent with the law would require us to not only state a compelling interest, but would require us to take action very narrowly drawn to meet that interest. In order to gain some guidance on this and define our power, the parish's attorney, Mr. O'Neill Parrington, earlier this year sought an opinion from the Louisiana Attorney General regarding what and how much discretion we truly had. Yesterday, we were furnished with the opinion of the Attorney General. The conclusion of the Attorney General was that although revised statute 33-101.1 grants us legislative discretion in approving or denying developments, the courts of Louisiana have greatly restricted this, stating, as I have stated before from the very beginning, that any action we took to deny an otherwise legal development would be subject to a strict scrutiny review. This has been the holding of the courts throughout our state and is the holding adopted by the Louisiana Attorney General. The Attorney General has cited the Second Circuit Court of Appeal, which sits in North Louisiana, the Fifth Circuit Court of Appeal, which sits outside of New Orleans, and most importantly, it's been the holding of the First Circuit Court of Appeal, which is both supervisory and precedential authority over the District Court in Ascension Parish, the 23rd Judicial District Court. To quote the various courts on this right of use and our powers, this is what the courts have said. When an owner seeks a use by right in compliance with the applicable zoning, conforming to every modification improved and approved by the Commission, this use by right should be presumptively valid and approved. On judicial review, the Council's decision to deny a use by right is subject to strict scrutiny, not the normal standards of broad discretion applied to variance cases. Additionally, land use regulations are construed in favor of the owner's proposed use of his own property. It is this basis that the Attorney General, in his letter to us, concluded, and I'm quoting the Attorney General's opinion, accordingly, the standard of review that will be applied by a court on judicial review of a denial of an application seeking approval of a subdivision when the plan meets all statutory and regulatory requirements is strict scrutiny. In reviewing a land use decision, the issue is whether the governing body acted arbitrarily, capriciously, or without any calculated or prejudicial lack of discretion. When applications are granted in similar situations and refused in others, the refusal to grant an application may constitute non-uniform application of zoning ordinances that is arbitrary and capricious. To determine if the decision of the Planning Commission or governing authority is valid, the court will examine whether the decision bears so little relationship to the public health, safety, and general welfare as to render it arbitrary and capricious. This opinion by the Louisiana Attorney General serves as a validation that this commission has, for at least as long as I've been on here, which has been more than 2 years, acted appropriately and applied the correct standards when reviewing new developments that have come before us. That's not to say that we don't have empathy and compassion for those who have come before us to speak against new developments. We do, and we want those voices to be heard, and they will continue to be heard with every proposal that comes before us. However, at the end of the day, we are bound by the law. If a development does not meet the standards imposed by law, then we should either not approve it or approve it only conditioned upon it meeting the legal standards. If, however, a development has met the legal standards, it is presumptively valid under the law, and we must, absent extraordinary circumstances, approve it. What I would say to people who wanted to stop growth in this parish altogether or severely restrict it is that we are an appointed body. We are here to enforce and apply the laws promulgated by the parish council. We are not a super legislature impaneled to impose our will above those who are elected and accountable to the electorate. If the council changes the laws, which is its duty and province to do if it feels it is appropriate, if the council tries to make building restrictions and new developments and the use of land more restrictive and passes ordinance to the extent, then we are bound by that law, just as we are bound by the current law, and we must follow those laws whether we agree with them or not, until or unless those laws are changed or declared null and void. Until then, the Unified Land Development Code is what we must follow. It is not a guide or a suggestion. It is not, hey, this is what we'd like you to do. It is what we must do. And we have followed the Unified Land Development Code for the last several years. We have applied the appropriate standard, and with the Attorney General's opinion of May 10th, 2011, we have been validated in all that we have done. And that concludes my comments for this evening. We're moving on to the general business. I would note that Mr. Christie has made it to the meeting. Number 7 on the agenda is approval or denial of the minutes of the April 13th, 2016 Planning Commission. Can I get a motion on that? So moved by Mr. Bishop, second?
Second.
Second by Mr. Chasson. All in favor? Any opposition? Hearing none, the motion passes. Number 8 is the consent agenda. Do I have a motion to approve the consent agenda?
So moved.
All right, moved by Mr. Dudley, second?
Second.
By Mr. Dumas. All in favor?
Aye.
Any opposition? Hearing none, the motion passes. Item number 9, public hearing to approve or deny the following family partition, Mary Melanson Babin property, lots A and B, by Land Source Incorporated. Yes, sir, please come forward.
Good morning, David Patterson with Land Source, 6730 Exchequer Drive, Baton Rouge, Louisiana. We got comments from the Planning Commission, and we've addressed all those comments, and I've already gotten a couple of calls from people that thought this was a 30-lot subdivision, and they were happy to find out that we're just taking one 6-acre lot and creating 2 lots.
All right. Mr. Bourgeois, you gonna speak on this?
I'm good.
I don't know. Let me see if I have that in my packet.
Short and sweet.
Oh, I see it, I got it, okay. All right, we're gonna go ahead and open a public hearing on this. Is anybody signed up to speak? Okay, we will close the public hearing on this. Commissioners, do you have any comments on this family partition? All right, do we have a motion regarding this family partition?
I think we have some people,
Mr. Could you move
we
to
have some
approve?
people here to speak that
Oh, I'm
didn't
sorry.
sign up.
Okay. Yeah, okay, sir, I'm sorry, we'll reopen the public hearing. Please come forward, sir. If anybody wants to speak on any issue, you must sign a card before we start, so it's okay. Please state your name, sir, and you have 3 minutes.
My name is Kevin Simpson. I'm just really here not to object, but to find out if the paper that is placed in the sign is what's going to happen, or is it paper what is already existing and something else? So that's really what was a little bit unclear. You couldn't really tell from the paper that was in there. It said a re-subdivision. You couldn't tell whether that re-subdivision was re-subdividing 2 lots into smaller lots, or if it was subdividing the 6 acres into 2 acres. And he answered that question. So I apologize, but we just wanted to get some clarification on that, and there was no mention of signing the card prior to the meeting.
That's okay, we'll let you speak, that's fine.
Okay.
Yeah, and just to let you know, it says, our packet says the owner is proposing a family partition of 6.24 acre lots into Lot A, which is 1.8 acres, and Lot B, which is 4.42 acres. The applicant will retain Lot B and transfer Lot A to her daughter. So it's going.
So for this particular area and all future, if there is a piece of paper that's on the back of the sign, that is what is being proposed for the area, not necessarily showing that this is what we have and we're going to be doing something with it. I think that was the bit of confusion that everybody had.
I had gone to the effort to put a little sheet holder on the back of the sign, because I figured some people would have questions, and it kind of backfired a little bit, but my name and number was on there, and some people called, and I was just trying to give some people some clarity, and so it backfired a little bit.
Yep, no problem with, that's how America was founded. No problem with subdividing and giving your daughter a piece of property. We weren't objecting to that.
Okay.
Not at all.
Thank you, sir.
Thank you.
Appreciate it. Is anybody else wanting to speak that didn't sign up? All right, well, then we'll reclose the public hearing. Commissioners, I'll go back to Mr. Christie. You move to approve it. I have a motion by Mr. Christie to approve the family partition. Do I have a second?
Second.
Second by Mr. Chasson. All in favor?
Aye.
Any opposition? Hearing none, the motion passes. The family partition is approved.
Thank you very much.
All right, moving on to number 10 on the agenda. It's a public hearing to approve or deny the following subdivision final plats. All 3 plats proposed have been withdrawn from the agenda, so we will move on to item number 11, an ordinance, a public hearing to recommend the approval or denial to the Parish Council amendments to the Ascension Parish Unified Land Development Code Ordinance number SR 16-07, revisions to the subdivision regulations in the Unified Land Development Code pertaining to wetlands determination. Mr. Bourgeois, do you have any comments on this?
Mr. Chairman, this is simply a change in, some small changes to the city code that would require wetland determination preliminarily, before a preliminary plat can be accepted. And before the final plat would be approved, then they'd have to show whether it's not in the wetlands or give documents indicating that it is in the wetland. And maybe legal may want to comment on it.
This is just a recommendation for you guys to send to the parish council. What it was is we were having a lot of trouble with regarding the definition of a determination versus delineation and what's actually required under each one. So this is just an attempt to kind of clarify it a little bit more and to just speed up the process. I think determination requires the developers to get full approval from the Corps, which takes 6 to 9 months, which doesn't really make sense before a preliminary plat. So it's just changing the word delineation, which is a little bit less of a standard, and they still have to get the determination on the back end before any construction, so.
Okay. We will go ahead and open a public hearing on the recommending, whether we're gonna recommend approval or denial to the parish council. Has anyone signed up to speak on this issue? No. We will close the public hearing. Commissioners, do you have any questions or comments? Hearing none, we will move on. Is there a motion to, regarding this proposal?
So moved.
To recommend approval to the parish council?
Yes.
Moved by Mr. Dudley. Do we have a
Second.
second? Second by Mr. Dumas. All in favor? Any opposition? Hearing none, the motion passes. We will recommend the ordinance change to the parish council. All right, item number 12 on the agenda is staff report.
We have none, Mr. Chairman.
All right, number 13, engineering staff report.
We have a report. I just was trying to get a handle of what type of reports y'all gonna want at these meetings, so I'm gonna try to continue what I've seen done at these meetings before, and it's just giving a quick rundown of projects, where they are and the current status. Right now in construction, it looks like there's approximately about 15 projects out there in construction. I'm anticipating the next couple of meetings there'll probably be 3 to 6 projects requesting a final approval at that time. As you can see, 3 of them that were on the agenda tonight got pushed. I believe that was due to some weather, so there's a bunch of them that are all grouped together at this time. There's about 5 projects right now that are all in the construction plan review process. The most recent one, a Maple Grove project, has just completed that. They'll be starting construction soon. And at this time, there's about 6 or 7 projects out there that are still in the preliminary plat. All they have is preliminary plat approval process. They have not yet gotten to construction document process. So, and since this last meeting, we've had 2 pre-application meetings. So it seems like the bulk of the projects right now are in construction, and there's probably another potential 6 or 7 that will get into the construction process probably in the next 2 to 3 months.
That concludes your report?
That concludes my report.
Thank you, sir. Moving on to item number 14, motion to adjourn.
So moved.
By Mr. Dumas. I don't hear any opposition. We will stand in recess for a few minutes before switching to the zoning meeting. Thank you all for coming.